Hello, everyone. Welcome again. Thank you for being here. I think we're going to start now. So to start the fourth Brazilian Arbitration Forum, we're going to have a brief presentation from Professor Diego Fernández Arroyo, then Eleonora Coelho from CAM-CCBC, and André Abbud on behalf of CBAr. I'll give the floor to Professor Diego Fernández Arroyo now.
Welcome everyone. Thank you for being here. It is a real pleasure to have at least a part of our audience here in Paris. I would like just to thank all the people who makes possible this fourth session of the fourth edition of the Brazilian Arbitration Forum, UBAFI. First of all, Bruno Sousa Rodrigues, with the help of Alexander Senegasnik, who really are the responsible for the good things that we can do this afternoon. Of course, I would like to thank my partners in the organization of this event. It's an event which started to be really spontaneous manifestation, only one-shot manifestation, but because of the success of the first time, we organized a second time, and the success of the second time, we organized a third, and now we are already in the fourth session. And my partners for that, José Ricardo Feris, here is the chair of the first round table here, and our friend Renato Grion from Sao Paulo. And last but not least, Eleonora Coelho, who is in herself responsible of many things, many good things in Sciences Po. She's not as a minor quality, she's the president of the CAM-CCBC, which is the most important arbitral institution in Latin America. But more important than that, she's a visiting scholar in Sciences Po. And it is this, I think this partnership with CAM-CCBC, which has assured the permanence of this event. In addition to that, we have, even if there is a competition between institutions, we have the help of the ICC Court, and thank Ana Silveira for being always supporting.
It's a smaller institution.
It's relevant in Latin America.
It's a new entrant.
Thank you, Ana, for being always supporting with the ICC Court of International Arbitration, this Brazilian Arbitration Forum, and of course, for the first time, we have also the partnership of the Brazilian Committee of Arbitration, which is for us a very good thing, and we are very, very happy to have the Brazilian Committee of Arbitration on board. So I know that it's already late. We are starting later than expected. So I will stop here and give the floor to Eleonora to say some words for all of us. Thank you very much.
Thank you very much, Diego. It is a great pleasure and honor for CAM-CCBC to co-organize the Brazilian Arbitration Forum for the fourth time. I still remember a few years ago when we were in Peru together with José, Ricardo, Renato, and you had this idea. And we thought it was a wonderful one. And our exchange of experience has been really rich. And we are very proud of this initiative. As you know, this is one of our missions in CAM-CCBC. It's always to keep improving and seeking for the best practice. In this sense, we are very happy to have our partners from ICC, and this year, the partnership of CBAr, which is a very important academic, I think it's the most important academic institution in Brazil. And we are also happy to inform that we have been organizing very many webinars since the pandemic start. We have organized almost 40 webinars, and we're going to have our conference in October. Everybody is invited. It's free of charge, so everybody can enroll themselves in our site. And you know, this is a great pleasure for us, Diego. You are one of the best professors I know, and students from Sciences Po is very lucky to have you there as their leader. And also us here in Brazil, we are very glad and really thank you so much for this partnership that we hope to keep on for the next years. And next year, I hope to be there in person.
Now, I would like to invite our friends from the CBAr. André,
Thank you.
please.
Thank you very much, Diego. I just want to welcome you all to the 4th Brazilian Arbitration Forum and say that this is a great opportunity for the Brazilian arbitration community to share its views on international arbitration with the broader international community, and for the international community to get acquainted with and discuss with Brazilian practitioners their perspectives on international arbitration. So it is not only natural, but also a great honor for us at the Brazilian Arbitration Committee, which congregates more than 1,300 members of the local bar, to support this forum organized by CESPO and CAM-CCBC with the help of ICC as well. So I wanted to thank Diego and Eleonora and congratulate you once again on this event. I wish you all a very insightful discussion during this afternoon.
Eleonora, thank you, André, for your welcome remarks. And also thank you for your support over the past 4 years, and also thanks to Sciences Po for having welcomed this idea that we had one day, and that now has become an integral part of Sciences Po's calendar of the year. It is a pleasure for me to be chairing this first roundtable, and it is a pleasure for me to have this roundtable with 4 excellent panelists, not just because I know them and I know how brilliant they are in terms of their careers and personally, but also because we have managed to put a panel that combines very interesting points of views. We have in the panel 2 current in-house counsel. We have 1 former arbitral institution officer, current outside lawyer, and we have 1 former lawyer, former in-house counsel, and now arbitrator. So in the panel, we really have managed to have all the points of views. And I think it's great to have all the points of views to discuss the issue that we're going to be discussing, which is not just construction arbitration in general, but the idea is to discuss whether construction arbitration is actually meeting the user's expectations. So that is the focus of this panel's discussion. Without further ado, we will enter to discuss the issues right away. we have chosen to discuss 4 aspects within this topic. 2 that belong to, let's say, how disputes can be avoided. And here we're talking about the role that dispute boards actually play when we speak about construction arbitration. And secondly, what we call contract management, which is essential when it comes to construction projects, because normally one would say that contract management is in itself a way to avoid disputes, to avoid construction disputes. And then we're going to focus on the arbitration procedure itself. And obviously, we cannot do that without discussing the role that experts play in construction arbitration, because by definition, construction arbitration is a technical matter. So obviously, we will need technical evidence to be produced. And then we're going to discuss case management in general, because as we all know, those of us who actually practice arbitration in this industry, construction arbitrations tend to be longer, tend to be more complex, tend to be includes more expensive, particularly when you prepare a budget for a construction arbitration. Normally it's going to be higher than your average arbitration. So all of these 4 aspects will lead us to find, hopefully, some conclusions, if not more questions, about whether construction arbitration continues to be the leading field in arbitration. I think probably Eleonora will be able to confirm, and Ana Serra will be able to confirm that the majority of the arbitrations in arbitral institutions are normally construction arbitrations, again, because of the technical nature of these disputes. We're going to have, we're going to go directly to the first issue, which is dispute boards. And to discuss dispute boards, we're going to have the views of Rodrigo Martini. Rodrigo is General Counsel of TECHINT, which is a Brazilian, it's the Brazilian affiliate of a multinational technology, construction and engineering company. He will be joining us from São Paulo. And we have our friend Gustavo Scheffer, who is, again, former ICC counsel, the first Brazilian counsel in São Paulo, once the ICC opened its offices in São Paulo, and now is counsel at Tawil Shekhar in São Paulo. So I'm going to ask both of them to give us their views about dispute boards. And here, perhaps there's a particular aspect that we're interested in. Those of you who follow FIDIC contracts will know that the FIDIC contract was modified recently to change the way in which dispute boards are seen, or to change the role of dispute boards. Dispute boards were used to be called dispute adjudication boards, and now they are called dispute adjudication and avoidance boards. The question that I put to Rodrigo and to Gustavo is that cosmetic or is that actually useful? And I would be pleased to hear your views. So Rodrigo or Gustavo, whoever wants to start, not the floor, but the screen is yours.
Thank you, Jose. I think I'll start and then I'll pass the ball to Rodrigo. But first, very quickly, I would just like to thank the organizers for this invitation. It's really a pleasure to discuss arbitration and construction arbitration with you all, and especially at the Paris Arbitration Week, which is an event and a city that I hold very dearly. So the question, whether is it useful or just cosmetic? I say, was the change necessary? No. Was the change useful? Yes. Why wasn't it necessary? When we had the 1999 editions of the FIDIC books, the arbitration, the dispute board rules that come on with the FIDIC contract, which are part of the contract. If you have the FIDIC book with you, after the model contract, you have the dispute board rules. They were very broad. So they gave very broad powers to the members of the dispute board to conduct the mechanism the way they see fit. And as the dispute board is a contractual mechanism, the parties were also able to agree in special mechanisms that they wanted during the dispute board, so to conduct it in the most efficient way. So the dispute board members were free to propose to the parties to have an avoidance system, and the parties were free to agree to have this avoidance system and then to apply it. So it was not necessary to make this change. They had the powers and the parties were free to agree. Now, was it useful? Yes. Why? Because in practice, what the FIDIC was trying to do was to put some accent on the role of the dispute board, which was to avoid dispute more than just resolve. What we could see in practice that the dispute board were there often just to wait for a dispute to arise and then quickly resolve it. And they were doing that very well, but we could go one step further. So the change was positive in a way that it puts emphasis on this very important role that we can even have it better. We can have a way that we don't have the disputes, that if the problem is arising or will arise because of the circumstances, the members can step in, the parties can also step in, they can talk about it and solve the problem before it becomes a dispute. And this change was much in line with many other changes of the FIDIC contract. And I give just one example, which is at the system before the FIDIC engineer. So Article 3.5 of the 1999 edition provided that if there was a claim, the engineer should act to agree or determine the matter. And in the 2017 edition, FIDIC maintains that the engineer should act to agree, but it actually puts an entire section, which is section 3.7.1 of the 2017 edition, which clearly provides a detailed procedure for the engineer to come out to the parties, reach the parties for them to discuss and try to find an agreement on the matter. So on the dispute board parts, the addition of the avoidance falls within this entire restructuring of the 2017 edition, which is more in a way of let's avoid disputes, let's agree on matters, let's take proactive measures to avoid reaching the stage of a dispute. So this is the overall view. It was not necessary, but it was very useful. The issue that in Brazil, maybe this discussion is still a little, unfortunately, too advanced. And this I would like to see what is Rodrigo's view. Often we don't get to the point that we have a dispute board on the contract, or if we do, the parties do not implement it at the beginning of the project. So we don't get to have all these nice discussions and see whether it actually is efficient here in Brazil. But I don't know if that's Rodrigo's experience and if you would like to share with us.
Thank you, Gustavo. Before I give the floor to Rodrigo, let me put a question on the table, which can be answered now or later as you both wish. And it is the following. When we're discussing dispute boards, the dispute board used to be a technical body. And it has become, with the time, lawyers tend to spoil things. And it has become the dispute board as a sort of like an arbitral tribunal. And when you have a hearing before a dispute board, it looks very much alike a hearing before a dispute, an arbitral tribunal. And now dispute board also, obviously they need to have requirements of independence and impartiality. But now with this new function of being, focusing on avoidance, dispute boards, they also are required to try to avoid the dispute. And that sometimes means giving advice to the parties as to how to deal with an issue before it comes a dispute. But then they will have to decide this issue. And I wanted to see your views as to whether you see some sort of conflict or clash there in the roles that have been put to the dispute board. One would say that it's as if we would ask the arbitrators to become mediators at the same time. But I don't intend to break the flow. Rodrigo, feel free to issue your comments first, and then if you want, you can answer the question later.
Okay. Thank you, José. Thank you, Professor Diego, everyone here together. It's a pleasure to participate in this seminar. It's very useful, very interesting to share ideas with such a great team. Going straight to the point, I do agree with Gustavo. Actually, it's the change, the question, DAB or DAAB, we need to make a step back and make another question from the Brazilian perspective. Looking the aim to solve the dispute or to avoid disputes, I see that in the Brazilian context, we use little resources, little tools to get to this aim. From my perspective, now in the construction industry, I see few contracts using this tool. We don't have any dispute board ongoing. The tool is being developed. We hear a lot of it. We discuss a lot of it. But I see that there's a need to improve knowledge on this tool. Parties need to understand let's say the value for money on it, because sometimes we hear we're going to spend money with the DRB or the DAB. The issue is the litigation or the arbitration, especially in the construction sector, costs a lot. So we need to think about saving money. Now, avoiding dispute is about saving money. So thinking about that, our environment here in Brazil still needs to be developed, by especially by lawyers, practitioners of law in any profession, arbitrators, lawyers, in-house counsel, everyone working on this environment should be aware of the importance of avoiding dispute. So this is the scenario I have here. Especially going to your question, I can say that if you look at this aim of avoiding dispute or settling the dispute once it comes, it's necessary to be careful about discussing some issues, but I see a value in aiding parts to get to settlement, either in a dispute board or in arbitration. Everyone that can help to settle the dispute, to get to this aim, is required to be there to do that. So it's very useful from my perspective, including now as an in-house counsel. It's a good question, because everybody thinks that we want to win, and sure, it's good to win, but what winning means? The issue is, if we settle the dispute, we are winning. And that should be the main goal of the whole work here. No. I don't hear you.
Yes, I think José is on mute.
I was on mute. Even without the microphone, I was on mute. It's the phrase of the pandemic. Sorry, Rodrigo, I was just saying that there's a say, probably in Brazil, you say the same thing, that it's better a bad settlement than a good fight.
Yes.
So I don't know, Gustavo, if you wanna have your take on the question that I asked. Let me put another question to sort of close this first topic, which is why do you think? I mean, and we're hearing here a very important person in the construction industry telling us that despite the fact that it is useful and that this tool of dispute boards is made to avoid disputes, and yet construction companies in Brazil are not using it. So perhaps let me add this second question, and perhaps very briefly, Gustavo and Rodrigo, if you want to add some comments on those two questions.
Yes, Jose. I'll answer the second question first, why they aren't using it so much in Brazil. And I think it's just a matter of culture. And I think it's about to change. And why is about to change? Because I think we had a very important new piece of legislation, which is the new public contracts law, which clearly provides for the possibility of having dispute boards in public work contracts. And once the public administration starts using it, this is going to spread. So I think this will help a lot to make dispute boards a reality in Brazil. If we left only to the private sector, which I'm usually the one defending that the private sector should be the one doing things and the state should have a smaller role, but at least there, I think they are going to have a useful function, which is to promote dispute boards, and it's going to be beneficial to the entire infrastructure industry in Brazil. As to the first question, whether there is a conflict between avoidance of the role as dispute avoidance and then later on deciding a dispute, you're absolutely right. The issue is very delicate, but I don't think we should make too much out of this conflict. And I'll explain why. First of all, there are techniques that the dispute board members can use to avoid disputes without actually having to go into the merits of a problem. So they could, for instance, draw the parties' attention to technical problems that they have in their experience, seen in other projects, and just raise it with the parties. Have you considered this? Are you aware that sometimes this happens? And so they draw the parties' attention and they start to get them to communicate with each other. So by doing that, they are helping the parties to avoid disputes without having actually to go into the merits of what would be the result of a dispute. And even if that would be the case, later on, they have to issue a decision on a proper dispute, and they will motivate their decisions. And they are a competent technical body that may give a very reasonable technical justification to their decision. And therefore, the parties could accept, or the parties in the FIDIC system could then, if they disagree, they could issue a notice of dissatisfaction for the matter to the arbitral tribunal to a final decision. And between this period, they will have a cooling off period of 45 days where they can negotiate. And they say, okay, they issue a decision where the employer lost for whatever reason. And the employer kind of accepts the overall direction of the decision, but there are details that the employer disagrees. They could refer the matter to arbitration, but before they could use the cooling off period to try to negotiate. Okay, I agree with the general sense of the decision, but can we reach an agreement on these 2 points? And then they find a solution. So yes, there could be some conflict, but in practice, I think the overall outcome is positive, and there are ways of, in case clearly there's an issue of prejudgment or a party feels that it was unfairly treated, there are solutions. So we shouldn't make too much out of this conflict.
Thank you, Gustavo. Rodrigo, do you want to add something here, or we can move on to the second topic?
Yes, I do agree with Gustavo's comments on this issue. Concerning the cultural environment, I would like to share two brief articles here. Let me see if I managed to do it. No, I'm not able to share, but anyway, there are two short articles that I use here as a reference to show internally in the company to people involved in negotiations and contract management the need to change their minds now to open to those ideas. The construction area in general is considered not friendly to big changes. But I can say from my own experience that I've seen resistance from clients. Now, every time we touch the dispute board issue, the answer in general is okay, we have heard about it, but we are not using. So this is important that both sides are involved in this question and trying to get to this point of developing the tool here in the construction sector, especially in Brazil. No?
That's a very absolutely a good point, Rodrigo. So let's move on to our second topic, which is also in a way related to pre-disputes or dispute avoidance, which is contract management. Is basically everything that happens during the project in a way. And here we're bringing in a new speaker, is Patrick Baeten, who is Chief Legal Officer of M&A at ENGIE, very well-known energy company. And here it's important to note that if construction is one of the main fields that use arbitrations, energy is the second one, and sometimes they are mixed because it's about construction of energy projects, right? So it's great to have Patrick here with us, who also spent some time in Brazil. The question with contract management is, what makes good contract management and why contract management fails? What are the obstacles that normally will make contract management fail? And so I'll put the question to you both. Maybe, I don't know, Patrick, maybe you want to start, and then Rodrigo can add his views.
I can start for
yes.
Sure. Thanks for having me. By the way, I'm back from Rio since August, and I'm already missing Brazil. So thanks for you being here. I mean, the view I had in
and the weather is similar.
Not quite.
Yeah, in the room.
Not quite. I mean, but I can tell you that the view I had from the office on the Pau de Açúcar is not to be compared with the view I had from La Défense. So, anyway, on a less pleasant note, no, for sure. I mean, I obviously agree with a lot of what has been said. I'm not quite sure that the best dispute is the dispute you avoid. I'm not quite sure that in any cases it's better to have a bad settlement, so-called bad settlement. A settlement, by the way, it's bad for both parties and good for both parties by definition. So, I mean, it's you know, it's a half that is half empty or half full. But anyway, I think it's pretty much depending on the circumstances. It's pretty much depending on what parties are actually, both parties are actually looking for, etc. But I think as a bottom line, what we're trying to do within ENGIE is obviously we try to avoid disputes for one good reason, and it's independent from time and cost, by the way. It's that it takes an awful lot of energy, an awful lot of negative energy, and by definition, it has a negative impact on the business plan as it was designed at the time of taking the investment decision, etc., etc. So everything we can do to avoid disputes from arising and then from crystallizing is I think good to take. Now, contract management has a very key role in this. It's as far as NG is concerned, I'm afraid this is off the record, but I'm quite sure that this is record. So
It's on the record. We can pause.
No, actually, we use it. We use it not often enough. We should use it a lot more, and we should try to design it in a way that it is the most effective. Now, I have at least 4 elements in this perspective. One, it's timing. So if you want to have an efficient contract management and an efficient claim management afterwards, because the two are linked.
Yes.
You need to have this in place right from the start, from the very beginning of the project. And if possible, by the way, you should have your contract manager on board whilst you're still negotiating the contract, because then at least he or she has the history, the background. So that is one. That's the start. And then obviously, well, most projects, at least in our industry, last for 1, 2, 3, and sometimes even more years. You got to make sure that it's the same individual who stays in charge. For the same reason, it's about background, it's about knowing people, it's about trusting people, it's about knowing why we drafted this letter and not that type of letter, etc., etc. If this is not possible, you should make absolutely clear that you have a smooth handover, meaning it needs to be structured, it needs to be documented, and if at all possible, you need to have an overlap between the two contract managers in time, in terms of time. So that is one, time. Second is positioning. Sometimes we had bad experiences because we had contract managers who were either not involved as such in the project, so they were not on site but somewhere else. They were not reporting to the project manager but reporting to whoever else, or they were part of the legal department, and then you enter into some sort of weird relationship. So the positioning is key. The positioning is key also for having access systematically and immediately to any and all information, which is obviously key. And positioning is important in terms of impact, because if the aim is to have a passive contract manager who's simply looking at the train coming by, I mean that's not exactly what you want. So that is 2. 3, as I said before, it's the scope. It's for me, it's both contract and claim management. And 4, but that's evident. You need to have someone who has both the right set of skills and the right attitude. And that's sometimes difficult. In terms of skills, that's relatively easy to circumscribe. Ideally, you should have either a legal profile with a technical background or the other way around. But you need to have someone who's accurate, who's methodological, who pays attention to details, who's hands-on, and blah blah blah. We all know the perfect CV. By the way, it's the perfect CV for the lawyers as well. And then preferably having excellent drafting skills. I mean, what I've seen, and I'm absolutely sorry to say so, in Brazil is we had a brilliant contract manager, but that person could absolutely not draft. So
in the arbitration, that doesn't help.
No, that doesn't help.
Because that's the evidence you're going to produce.
Of course. So that was a bit of a pain, but okay, that's it. Now all of this, and then coming back to what Rodrigo said, clearly this requires a budget, but that budget is not to be compared with what you would have to pay if after this you would go to either disputes boards or adjudication or arbitration or whatever. So from that perspective, I think we as in-house counsel have a really fundamental role in this, making people understand that if you have a very tiny additional line in the budget of the project, which is paying the monthly fee for the contract manager, it's really worth something. Really worth something. Albeit to avoid outside counsel.
Yes, exactly.
Not exactly the same order of magnitude.
May perhaps be more expensive. Rodrigo, your take on this on these 4 points that Patrick has shared with us. Very, very useful 4 points.
Patrick's comments are perfect for the situation. I totally agree with him. This is the practice we put in place here in company about when talking about contract management. But I can say there are two bullet points to share with you regarding this issue, and having in mind that finding one person that has all these skills necessary to achieve this aim is tough. No, so the first one is don't fight with legal department. Now, engineers and lawyers need to work together. So contract management is about working together. So legal department is here to help, and this is crucial for the success. And one very important thing that Patrick mentioned is working on the subject since the very first moment of the negotiation, the contract. So we are talking about evidences. When a dispute comes, it's not the moment to seek evidence. Everything should be organized in the company, in the files. Those skills are very important to organize information, the whole contract management. But when it comes to the moment, evidence should be there. Those are my observations.
Excellent, Rodrigo. I think with these very useful points, then we can move on to the arbitration itself, and the most evident point to touch upon is the issue of the experts. And you may know there are more or less two types of experts, or two types of procedures for the taking of expert evidence. The first one is the most used in international arbitration, which is each party will present an expert, and the arbitral tribunal will try to use techniques in order to decide what is the best approach. And the second one is to ask for the arbitral tribunal to appoint an expert, which is the tribunal's expert, and which in my experience is the most preferred option in Brazil for some reason. I think that the Brazilian experience is different there than the international experience. So in order to discuss that topic, we'll bring in a new speaker, the last one of the panel, which is Katherine Spyrides, who is arbitrator with the Bois-Saison arbitration in Rio de Janeiro. She used to be also an in-house counsel at Vale, and before that, a lawyer in many firms in Paris and in Brazil. And I'll ask also there Gustavo to comment on that topic. Perhaps Katherine, you want to start, and then Gustavo will give his views on that.
Thank you very much, and thank you for having me here and for the invitation. After a long period behind the screens and monitors, I'm very happy to be here in person, and especially with you and in this city. That means a lot to me. Actually, I would like to add another model to those two that you have already mentioned. Of course, that in construction and infrastructure arbitrations, the production of the expert evidence is it's necessary almost all the time. But I think the importance of the case management conference and the discussions between the arbitral tribunal and the parties before establishing and designing how this is going to work is essential as soon as possible, because sometimes we think that we will need an expert evidence for everything, and we don't. So this is the first way to reduce costs and reduce time. The second thing, if we need an expert evidence, in which nature will be needed? And more than that, do you know the scope scope of the works, the limitations, what do you really want to prove? So bear in mind that, and bear in mind that the production of the expert reports will be really necessary. I would like to add this other model. That is if the parties wish to jointly agree to appoint a single expert. In this model, the parties will be jointly responsible for the appointment, for the selection, for the remuneration, and as well as to the instructions that will be handled to the expert. I know this is quite rare, and I thought about Anna yesterday. The reason is very simple. Lawyers avoid one-shot strategies. Anna yesterday was talking about arbitration as a single-shot procedure. So you can imagine a single strategy in a single-shot proceeding. It's very complicated for lawyers, but nevertheless,
too much risk.
Yeah, too much risk, and only one shot. So, but my idea of bringing this here is that nevertheless, I have experienced two very interesting and successfully experiences in this regard. But I believe that the success is due to the huge involvement of the parties. The business areas were diving deep on the matter. I believe that the scope was very well delimited, and also, the amount requested by the parties were not so distant between each other. So I believe that due to these characteristics, very specific to these two cases, it worked well. But despite of this, you're right, the usual model is that each part appoint its own experts, let's say this way, or in addition to those experts, the tribunal appoints a third one. Thinking about costs, of course, that having the third one will cost more. Thinking about time, the reason is the same. You're gonna need more rounds of reports. You're gonna need more rounds of replies. You're gonna delay your proceeding naturally. But the thing is, when you have a really complicated issue, and you have certain important discrepancies between the experts' reports from the experts appointed by the parties, how are you gonna deal with it? And at this point, I would like to change some ideas with Gustavo, because I want to understand in his view if it is really necessary to have a third one, or the arbitral tribunal and the parties can handle it differently without the need of having a third appointed expert by the tribunal.
Gustavo, Cachita threw you the ball.
Yeah, and I have another question. Gustavo. Do you understand that in cases when you have a Brazilian presence, let's say a Brazilian party or Brazilian law, or a Brazilian element or Brazilian council, if it changes, if this reasoning changes? He loves the subject.
I know. So do we have Gustavo or Rodrigo?
Yes, I think if I speak, there it is.
You may want. Here it is.
Yes. Well, when I first heard this question, I thought about two words: control and predictability. As counsel, I like to have control over the procedure. As far as possible, I like to have control on the outcome of the dispute. And for that reason, I much prefer the system of party-appointed expert. You add to that the factor that when we have a neutral expert or an expert appointed by the arbitral tribunal, counsel usually fear that there could be some type of delegation of a role that should be performed by the arbitral tribunal will be done by that expert, because then the arbitral tribunal, if the expert said A, the arbitral tribunal they're not engineers, they will simply then adopt the solution given by the expert. So as a general rule, I much prefer to have control and to have the arbitral tribunal decide the dispute on the basis of the evidence submitted by the parties. And here, answering Katherine's first question, I think the general rule is that the arbitral tribunal will be able to decide the dispute on the basis of the technical evidence submitted by the parties. They will have the case, they can apply the applicable burden of proof rules. So a party has to prove their case, they have to establish the facts, the technical grounds, and they do that with their pleadings, the technical experts. And when they say, this is the interpretation of the contract, and this is what happened technically, and then they give a proper reasoning, and the expert report shows why they are adopting the assumptions that they are doing, and there is reasoning there, the arbitral tribunal can read that. If the other side provides better evidence that's presented in a more clear way, then they will, okay, I'm not convinced of claimant's case, or I am convinced of claimant's case. I think that the cases in which applying rules of a burden of proof and interpretation of the contract and the evidence are the case in which that's not possible is exceptional. So if the arbitral tribunal will go for an independent expert, I think it should be for exceptional circumstances. It should be limited. And then it comes to the second word that came to mind, which is previsibility. If they are going to do it, I like to know it early in the case, if that's even a possibility. That's why I am a big fan of the procedural calendar being established and providing, of course, with flexibility. If something happens, we can change and we can adjust, but have a full calendar. And with the rules, parties should provide their memorials with technical expert reports, and all evidence will be submitted by this date. We're going to go to the hearing. We're going to discuss these issues in detail. This is previsibility, foreseeability of the case, control. This is, in my opinion, that's the better way to go. It's very frustrating when you work very hard, you present your case in the best way possible, and later in the proceedings, the arbitral tribunal decides, but you know, one side didn't really submit sufficient technical evidence, so it's better that we go for a neutral expert. I think if that's the road that the arbitral tribunal would like to adopt, I prefer to know it very early in the case, and then the entire strategy of the case is adopted that way. But as a rule of thumb, ex-party appointed expert, in my opinion, is the best way to go. And then I actually forgot what was Katherine's second question. You had a second, right?
Yes.
He's
The second, no, he didn't.
Okay, so the second one is when you have a Brazilian element in the case, the law, the party, the council, if this could impact in the choice by the parties of the model that will be adopted for this expert evidence.
Yes, for sure. Arbitration is also a matter of culture, like contracts, like we were speaking about DVs. So if you are in a very Brazilian setting, chances are that the arbitral tribunal will adopt a neutral expert method, because that's the rule that now is being used in our state courts, because that's what many lawyers are used to do. I think other sociological reasons to why this is also the rule here, maybe it's the way the market is. Having a party-appointed expert is a lot more burdensome for counsel. It requires a lot of work to submit a really good expert report. Maybe if some counsel have a lot of many more cases, they prefer something more flexible. They just provide the questions and the expert will analyze them. I think there's more to dig into sociological reason why this is the case in Brazil. But definitely, if you have a very international arbitral tribunal, and by international, it could be only Brazilians, but Brazilians that are more acquainted with the international practice, then you will have the party-appointed expert system. If you have a more domestic settings, I think the prevailing system will be the neutral expert.
Very good, thank you. And this ties in with the last topic that we're going to cover today, which is time and costs. And I'll ask, and I know Patrick wants to comment on this topic, but perhaps it ties in well with the last topic, which is, do we really, are users really interested in innovative ways of case management, or we just stop doing conferences about new ideas and just resign ourselves to the PO1 that we know and the terms of reference that we know and just carry on with that?
No, so the short answer is no. Do not stop trying to be innovative and to come up with other solutions. I'll come back to the reasons a bit later. Let me start with one example, and that's the link with the subject.
Yeah.
With the expert. I mean, it's from a user's perspective, it's a fascinating discussion whether you need to have 2 times 1 expert plus 1 neutral, or just 1 neutral, or whatever. Bear in mind that in some cases before that you had an adjudication, and which was not really an
additional line in your spreadsheet.
So I mean, it starts to be one way, and it's a bit of provocative thought, but I would be interested in having your reactions. One way to avoid this, and I'm not pretending that users in general or NGO in particular is mature enough for this, but one potential way out for this, especially in construction arbitration, would be to say, well, we appoint the co-arbitrators. Let's not pick lawyers. Let's pick engineers, and that's those engineers pick up a lawyer as the chairman of the tribunal, and most probably you will not need anymore all of those lengthy technical reports, etc. Or at least if you get those reports, they will be kind of assimilated and understood immediately by the co-arbitrators. And that's a way, by the way, that might be useful also to get people and the 2 parties growing together, because those 2 co-arbitrators, both technical people, might be more inclined to find some sort of common ground, at least on a certain number of topics, which then boils down the discussion on very few points, which then has an impact on time and cost, etc. But okay, that's just one suggestion. On time and cost, I mean, a lot has been said. I mean, you're certainly familiar with the Queen Mary surveys on international arbitration. I mean, over and over again, every single year again. I mean, there are 2 topics coming back. One is arbitration is the preferred way for dispute solving for in-house counsel, and second, but they're extremely dissatisfied with timing and cost. So it's a,
how do you put those 2 together?
I mean, I think once it comes to real adjudication, you basically have 2 ways. Either you go for arbitration or you go for the judiciary. The judiciary in most of the cases, especially in construction, true in general in energy, is in most of the cases not an option for at least one of the parties, because you don't want to fight before the domestic courts of Europe, for good or bad reasons. Mostly for good reasons, by the way. So the next best, by definition, is arbitration. And yes, arbitration can be lengthy, but in my experience, it doesn't last longer than the judiciary. Also because of the one shot, because there's no appeal. And I'm putting aside the enforcement problems you can have, because that's a topic in and of itself, especially with constructors, by the way. But so that is, I don't think there's a real difference in timing. There might be a difference in costs, but then 80% of the cost of an arbitration, I mean, recent surveys, including from the ICC, by the way, maybe you would be still when the survey was done. I mean, 80% of the cost.
No responsibility.
No, of course. I mean, 80% of the costs are counsel, and both legal counsel, obviously, outside counsel, and expert costs. So, I mean, if there's something to be done, I mean, it's either in avoiding getting to that point, hence the importance of alternative dispute resolution, etc. You should first try to avoid. If you can't avoid, you should try to settle up to a certain limit, obviously. and if you can't settle one, then you need to do everything you can, well, within certain ethical and moral limits, clearly, but everything you can to win. But again, I think, and this is another paradox from in-house counsel. Yes, we're complaining about lengthy procedures and costly procedures, but in the end, I mean, let's face it, if you're discussing a major construction arbitration and you're discussing tens, if not hundreds of millions of dollars, I mean, frankly,
in 6 months, right?
The 2 or the 3 million you will pay for, maybe even 4, for a state-of-the-art arbitration with top lawyers and top arbitrators. Okay, in absolute terms, it's a lot of money. It's far less than what investment bankers, which I'm now meeting, can ask for whatever kind of tentative deal. But
and you accept more than 3 months for the rendering of an award, right?
No.
that you want.
No, by the way, if I remember well, I was a bit surprised, and I said it in another setting a couple of years ago, when the ICC came up with the really brilliant idea to have expedited proceedings. I was a bit surprised to see that the timeline for expedited proceeding is 6 months, whereas in the standard procedure it's 6 months as well. So, I mean, no, right? So let's stick to the expedited proceedings.
Sorry, I said I went for your nickname.
Yeah,
but it's
I know
Katherine
it's stronger than you. I know. No problem. Actually, you asked if there is something else that we could do about time and costs, about management of the case.
We have one idea already, a powerful one.
I have to
Yes, I have to develop this one. Yeah, true. But I have some comments to add about it. The first one is what we already have. I believe that arbitration offers very good features to helping in the management of time and cost and the whole case. But as Rodrigo and Gustavo told about the dispute boards that exist in Brazil and are not used, I believe that we have good tools that are not necessarily used or well used. This is one point. The other point is that we used to speak about time and costs, and the expectations of the parties are broader than that. They have other expectations than the time and cost, but this should be expressed in a certain way. And here I always like to think about the issue of the communication, and I'm talking about communication at all levels. I'm talking about the business areas, the legal department, external counsels, tribunals, even the arbitration chambers. I think that the power of a good communication, and I'm not talking about a blah, blah, blah one, but a real communication with based on 2 pillars that one, the person who will, let's say, send the message or express its point of view, takes the opportunity to do so, and do so clearly and honestly. That's the transparency that we always call. And on the other side, we need people that are open to listen and really listen, because otherwise there will be no communication. And why I'm so worried about that, and maybe Patrick can share his views with me, because first, I believe that people do not communicate well 100% of the time. This is a fact. It is what it is. Second, and here Patrick made a commentary about the turnover. In my experience, the turnover in construction areas and construction companies are very high. And this is natural because people work from project to project. So I would like to hear a little bit more. How do you do to keep people, if not in the same project, but link it to an next project? And the third one, talking about the communication, it's that strategies changes. It changes all the time, and you need to be very updated, and you have to build a good relationship and a good communication with the areas to know exactly what they want. Third comment about suggestions. Maybe what we can do about suggestions is try to involve more the legal department, the in-house counsel. And how we can do this? We can ask if they want to participate. If we can ask if they want to be in copy of in the communications, or if they would like to participate in the pre-hearing conference or the case management conference or other things. Patrick, I know I'm creating more work for your team, maybe. You're not going to be very happy, but I believe that the more the in-house and the legal department are involved, this will reduce costs because there are many comes and goes, and it will reduce time as well. So that's the comments that I would like to add to this point.
Well, I think there's a lot of there are a lot of ideas on the table, but as usual, there is very little time to discuss them. So we have, with these 4 topics and these excellent participations, we have exhausted our time. And I'd like to thank you all for these very provocative topics. I know that I'm sure that what you've said will continue to be discussed in the corridors or even after the conference. We have 3 other panels today with very interesting topics as well to discuss. So we're going to leave it here. But again, thank you so much. I think it's a very strong start for the afternoon. And I want an applause because people do applaud, right? We're no longer in Zoom. Thank you very much. So I'm going to go now to the next, and thank you all in Sao Paulo. So Diego,
that's me. It's Bruno.
Bruno is going to be the next chair. So Bruno, the table is yours.
Thank you.
Mas tem são choras, não é? Porque eu acho que aqui a gente pode ficar assim, mas...
Better?
Yes. Yes. So now I would like to invite Monica and Isabel to take the result. Je n'ai pas tout. Parce qu'en fait, j'ai vu déjà. Non, je suis désolée, je les ai mis toutes les deux parce que j'allais en prendre. Je pense que c'est pour faire aux autres. Sim,
Bom, queridos,
um caso linguístico.
queridos amigos, vamos começar o próximo painel. E eu tenho um grande prazer de moderar o painel que continua sendo sobre ADR. A gente acabou de falar sobre dispute boards. Agora vamos falar sobre mediation. Então, temos muitas ameaças. I don't know why I was speaking in Portuguese. It's insane. Apologies. It's just yeah, exactly. So I will restart my speech. Apologies. Apologies to all. It's the Brazilian arbitration, exactly. So anyway, thank you very much for being here. I have the pleasure of mediating another panel on ADR. So we just had a very insightful panel on dispute boards, and now we get passed to another threat, maybe to arbitration, which is mediation, right? And for long, mediation has been considered a lesser, or maybe for some, a lesser type of dispute settlement because it was difficult to enforce mediation agreements. But this has changed when, or at least the ambition is to change that this fame, and a game changer could have been the adoption of the Singapore Convention on Mediation Agreements. So our panel is exactly on this topic. The Singapore Convention, is it a game changer for arbitration? Is it a threat? Is it not a threat? Is it a game changer for mediation itself? So in order to address those many issues, we have with us today a great panel. On my side here in Paris, I have Filipa Cansado Carvalho, who has more than 20 years experience in conflict avoidance and dispute settlement. In 2020, she left a leading Portuguese law firm to found her own law firm, FCC Arb. And now she focuses her work exclusively on mediation and arbitration in her capacity as mediator and arbitrator. Joining us from Brazil, we have Mônica Salles de Lima, who is also a practitioner with more than 20 years experience in conflict avoidance and dispute settlement. She's a partner at Fonseca e Salles Lima Advogados Associados, and she's listed as a mediator by a number of institutions such as CAM-CCBC, CBAr, and Câmara Mediari. And finally, in our panel, we have also Isabel Cantidiano, who is a partner at Cantidiano Advogados, and she's a graduate from PUC-Rio, and she holds an LLM from Cambridge University. And in our panel today, we decided to have a more conversational outlook in order to, avoid, the boredom of the afternoon. So we're gonna interact in the sense of posing questions and then having replies. And I think in order to start this conversation, maybe some of us need some background information because not all of us are acquainted actually with mediation. So I would like to bring Isabel into conversation, and maybe she could give us some background information on the current status of mediation in Brazil. So the floor is yours, Isabel.
Hi, Bruno. Thank you very much. It is a pleasure to be here, even if online. I regret not being able to sit with Filipa and you in Paris. It is a shame I couldn't be there. Next week, I have my second shot at the vaccine. Maybe next year I will be there with you. So thank you once again, the organizers, Professor Diego, you yourself, José, Ricardo, Renato, Eleonora, for inviting me and to be here in this all-female panel with Filipa, who is a good friend, and Mônica as well. That being said, to set the status of mediation in Brazil, it is impossible not to think about the evolution of the legal framework we have witnessed here. So the status nowadays, and I know Mônica is a practitioner in that area. She can talk more about that in a minute. But we have seen a great increase in the number of mediation procedures in Brazil, especially in the commercial area, which is, the focus of the Singapore Convention. And that is because in 2015, we have enacted a mediation law together with a reform of the Civil Procedure Code in Brazil. So that has changed. I mean, the culture has been changing for a long time. I remember I was talking to Monica before. I was part of a postgraduate course in 2003 in Rio about mediation and negotiation. And back then we had two bills for mediation laws going on. I mean, that was almost 20 years ago. And only in 2015, the mediation law was enacted in Brazil. So we have been talking about the evolution of mediation for quite a long time. And to put it together with arbitration, I mean, we have seen also a great increase in meta-arb clauses, and especially in the commercial area, business transactions have been including it in its contracts. So in my practice, I have been seeing also an increase in mediation procedures, not always successful, I should say. I think we have a lot to go and to evolve in that area, especially in the lawyers training, I think. But we have seen a big increase in commercial mediation in Brazil also, I should say, because of the chambers which have procedures and have been making it possible for these procedures and for these mediation to occur. So I think the status now is I should say, and Brazil has signed recently the convention, the Singapore Convention, and it's been increasing for the past 5 to 6 years, I think.
Okay, thank you very much, Isabel. You refer to changing culture, and this brings me to my second question. And the second question is, let's say, Lusophone lawyers, and here I want to address this issue with Filipa. Lusophone lawyers, but specifically Portuguese lawyers, are they acquainted or sufficiently trained to perform mediation proceedings?
So before I answer your question, just three quick notes. First, I was very excited when I was invited to speak at the BAF. This was in December 2019. So I'm super happy to be here 2 years on, almost. And I'm particularly glad to be in an afternoon of discussion of arbitration and mediation in a Portuguese-speaking environment, although in English, in Paris, and with great weather on top of that. So thank you so much for the organizers for having me here. And two warnings. One is that because time is short, I'm going to have to generalize somewhat. And the other warning is that I've noticed that I tend to say arbitration when I want to say mediation sometimes, speaking at conferences. I don't think this is a Freudian slip. I think this is just force of habit, so bear with me, please, and just raise your hand if you see me saying arbitration when I should have said mediation. So on to your question. The answer is obviously the answer that lawyers give to almost every single question, which is, it depends. But that's not a very interesting answer, and it does not really advance the conversation. So I'm going to say that I think that Portuguese lawyers are still not sufficiently acquainted with mediation. And before I elaborate on this answer, I think it is important to provide a little bit of context. So mediation, commercial mediation in Portugal, although it is increasing, it's not a big increase, as Isabel was saying in Brazil, it's a small, steady increase, but it's still rather insipid. And we have, so the state, in order to try to eliminate pendency, has fostered public mediation, family, criminal, labor, small claims mediation, which for a number of reasons is much more visible than commercial mediation. And the way these mediations take place are not always necessarily the most appropriate and appealing way for business people to solve their disputes. But they are unfortunately sometimes the only contact that business people and business lawyers have had with mediation. So there's a certain, they taint these people views in mediation or regarding mediation. Then there is Brazilians speak about tropicalization of things. We don't have a similar term for Portugal, but Ricardo was saying that lawyers destroy everything they touch. And there's a certain tendency, as we saw with dispute boards, to arbitralize everything. And lawyers in Portugal do that with mediation. So traditionally, lawyers would choose, would focus more on someone that had, in their view, a lot of experience and was experienced as someone older with a lot of experience as the party saw it as a lawyer or sometimes as an arbitrator, and not necessarily pay attention to specific training as mediator. Lawyers also act the same way in mediations, or not all lawyers. If you take Mariana, for instance, Mariana will know how to act in a mediation, but lawyers that don't have training in mediation, they just act as they would in an arbitration. And sometimes the parties are not even present in the mediation. So it's very, very legal. And all this context, which is compounded by confidentiality, which makes it difficult to share success stories, results in a lot of lawyers not understanding the benefit of having something that Katherine has said, not recognizing the benefit of having a neutral third party assisting you in a negotiation, because they say, I've been negotiating all my life, I don't need help. But as Katherine said, people don't know how to communicate very well, all of us. And it does make a difference to have someone that was trained in communication, in problem solving, in thinking outside the box, and in negotiation as well. And that introduces a change of dynamics in the parties' negotiation. So there's clearly, I think, a benefit there. And lawyers also do not always acknowledge the advantage that it is to have the possibility of having a not strictly legal solution, and of the empowerment that parties have in taking the dispute into their own hands. And so, but this is, I do not mean to criticize, this is an observation and an answer to your question, because I was for a long time one of these lawyers. So I'm not, this is not a blame game here. It is more looking forward, which is what you do in mediation. This is how can we solve this? And the thing, it's already being addressed. So people that believe in mediation, that know it works, and institutions have to create more opportunities to discuss mediation and to educate people about mediation. And that's actually happening. So to end on a more positive note, there are a lot of lawyers that have now studied arbitration, much of them younger lawyers, but also some of the older lawyers that promote arbitration and with their clients as well, that know how to act in a mediation, know how to use it, mediators that have been properly trained. So I think they're in the right path. So.
Okay, it's a very positive
Bruno,
note.
can I make one additional comment to what Filipa said? Sorry to interrupt.
No, not at all, because I would pass the ball to you now, actually. I wanted to
Before addressing culture and training, which I think is one of our topics today, I would like to make an additional comment about what Filipa just said, because we have seen the same movement here in Brazil. I mean, when back in 2002, 2003, we had these bills I mentioned. All we could see, I mean, the majority of mediation procedures we could see in Brazil were like family and conflicts of neighbors, always person-to-person mediation. And what I think happened, and I think we're going to get there soon in our conversation, the topic about culture and training, but we have to separate when we talk about commercial arbitration, commercial mediation. See, Philippe, I did the same thing, commercial mediation, and like judicial mediation. I think the mediation law in Brazil has been an incentive to mediation in the judicial way, but also has brought to the attention the possibility, together with other initiatives and obviously the Singapore Convention as well, of the importance of commercial and business mediation, which is, I mean, the topic of our conversation today. But we can see an increase both sections. And I think we still need training in both of them as well, but we'll get there soon. So thank you.
Now, this is a very important caveat because it's important for everyone to know that the Singapore Convention actually excludes those disputes of a family nature, consumer disputes from the scope of the treaty itself. So we are here talking about international commercial mediation rather than, as you say, judicial mediation. So let's get back to the topic of training and culture, because this is something that actually interests me a lot. So could you maybe say some words on how is, let's say, the training in Brazil for commercial mediation specifically? How do you see the landscape right now? Isabel.
Thank you. Yeah, I see. I mean, we have, it is hard, we know, to change a culture. I was talking to Monica before, and I was telling this story I just told about being in this postgraduate course in, I mean, almost 20 years ago when I first had my contact with mediation. And I remember thinking about following a path in mediation back then, and it was impossible, especially in the commercial area. I'm a corporate lawyer, and I remember having not many options, either academic or professional 20 years ago, 18 years ago. And we have seen a great change since then, I think. We have, I mean, both Brazilians and Portuguese, we have this culture of litigation, this culture of, as Filipa mentioned, expecting someone to decide for you instead of being yourself part of the process of the solution. So it is hard to change a culture. We know that. But in the academic perspective, we have seen many changes in Brazil, I think. One of them, for example, is that since 2018, law schools are obliged to offer in the syllabus disciplines as mediation, negotiation, and arbitration. This is one big change. I myself didn't have these subjects when I was in law school. So, I mean, that's a start, I think. We have also many courses and certifications ongoing. I know Monica is the vice president, I think, of the Brazilian segment of the ICFML, which provides certification both for mediators and lawyers in mediations, which is, I don't think it's, I mean, known by everyone. It is very important because we have lots of, since the mediation law in Brazil in 2015, we have lots of courses for mediators, but we don't see as much for lawyers in mediations. That's what Filipa was telling us ago. So the ICFML has that as well. And we have the mediation competitions going on. They are recent as well, not as maybe well known as the arbitration moots, but they go on. I know the ICC has one, the CAM-CCBC has one. So we have the universities organizing themselves to participate in these competitions. The ICC, for example, last year has the task force for mediation. They conducted interviews with practitioners in the area to understand what are the difficulties of commercial mediation evolving in Brazil. So I know they have this report going on as well. So we have many initiatives. CBAr, for example, has also a mediation group, which is the largest study group in CBAr, which is called GEMEP. It's for commercial mediation as well. It has more than 100 members, I think. And they organized an annual conference. Last year it was about the Singapore Convention, and this year it's gonna happen in October. So I think we have been investing in the academic training, if I should say, but I think there's a lot to go still in the part of the lawyers training and to practice mediation as a lawyer, which as Filipa mentioned, and I know Monica is going to talk about, requires skills that are not the ones necessarily used for an arbitration, for example, or just common litigation. So I think that's our path now.
Well, thank you very much for your insights. Monica, let me bring you to the conversation. As an experienced mediator, I wanted to hear your thoughts on whether the Singapore Convention will be a game changer for arbitration. Do you see it as a positive influence or maybe as a threat to arbitration? What are your thoughts on this? I think you're muted. No.
We don't.
She's not muted.
She's not muted. Monica?
That's a tricky
O microfone dela.
Monica, can you maybe put some headphones because we cannot hear you, although you're not muted. You just. Yes,
Maybe
that's true.
Maybe she should log off and log in again. Don't you think it's a better solution?
Yes.
Yes, let's try this way because we cannot listen to you. Okay, so we should have the technical sounds, little song while she logs in. So I don't know, maybe we should move to the next question while Monica comes back. And it is actually a similar one, but from the mediation perspective, and this was suggested actually by Felipe herself, because when I was asking, are you here?
Hi, can you hear me?
Perfect, yes.
Oh, good, great.
That's lovely.
Just a little bit to jump in the discussion. So first of all, good afternoon for everybody. I have to say that it's a huge pleasure to be here with my colleagues, Felipe and Isabel. And thank you for the organization, for the invitation to be here. And speaking about mediation, it's something that's very, very good for me and the practice of mediation itself. And I would like to add a comment about what Felipe and Isabel said about cultural changing, how to learn and how to educate the lawyers on mediation. This is a slow movement because changing a culture is very hard. People are very attached to the beliefs. So a good lawyer is a tough lawyer. So change this way of thinking and change the mindset. What are the skills a lawyer needs to be in a mediation table? It takes time. But I'm very hopeful with the young lawyers because of the whole this movement Isabel mentioned. The competitions, nowadays we have those methods in the faculties, and so it's very good. I see with a very good moment for the increase of mediation and the others ADRs methods. So addressing specific your question, Bruno, about the convention, Singapore Convention specific, if it's a threat to arbitration, in my point of view, it's exactly the opposite. I don't think there is any danger for arbitration in the Singapore Convention. It's the opposite, because the most important purpose of the Singapore Convention is to facilitate international dispute resolution by making the settlement agreements resulting from mediation directly be enforceable. So this is very important. It is enforceable in the course of the signatories. And what was exactly what the New York Convention did to the arbitration. So I don't see any danger for arbitration. I think the Singapore Convention helps to put the ADRs on the spot as reliable methods for resolve commercial disputes. So the Convention on Mediation, in fact, adds a valuable tool to international dispute resolution toolbox for cross-border commerce. I think this is an advantage. And as a side effect, the signatories of the convention helps to promote trustful environment for business, international business, and negotiation. So more business, more questions to solve. And so it's not any damage for arbitration. We know that one method doesn't fit for all situations. And so arbitration cannot replace litigation. So the same way, mediation is not going to replace arbitration. It's important to identify, according to the contract and the specific situation, which method is the best for the case. Here is an important role for the counselors and the lawyers. Mention again how important it is to educate the lawyers. Try to identify the best method for their clients. And I do not believe that mediation fits for everything, for all commercial disputes. So this is a great job for the lawyers and counselors to identify this situation. And also, I would like to mention that these methods can be combined, mediation and arbitration and others ADRs methods. There's a strong tendency nowadays to create customized solutions, tailor-made, specific for each specific case, and we call that hybrid methods. One example, I'd like to add one example of hybrid method is the mediation window, which could take place during the arbitration procedure. And so, for example, the arbitrations can identify a window, a moment of a possible agreement related to a specific matter and propose to the parties a mediation process to negotiate those points. Depending on the country, the mediator could be or not the same person as the arbitrator. Here in Brazil, we have a strong tendency to avoid this coincidence between the arbitrator and the mediator. So if the mediation reduces the scope of the arbitration, it can provide efficiency to the process, saving costs and time. So I think the combined methods is a very good way of treat some disputes, especially the complex disputes. So Singapore Convention is not a danger for arbitration. And just something that could help the method and the disputes. This window, this mediation window, can take place at the same time of the arbitration or during a short break. Nevertheless, in case the agreement doesn't happen, the arbitration continues providing a global decision without prejudice for the parties. So in this scenario, promoting mediation as an effective and enforceable method, this is very important to stress that, the enforceable method for resolving complex disputes, it helps to growth of the ADRs in the whole world. All ADRs. Mediations bring much more, and the Singapore Conventions brings much more advantages than the disadvantage to arbitration. So I don't know if Isabel or Filipa would like to add some comments on that. Just some thoughts about how mediation and arbitration can collaborate one with other.
I have one comment, if I may, Bruno.
Definitely, go ahead.
It is curious to note that in theory, when parties settle an agreement through mediation, we wouldn't think it would be necessary for us to have a convention about the enforcement of that agreement, of that settlement, because the parties did it together, right? I mean, so I think, the signature of the Singapore Convention brings an incentive from the states to the use of that commercial mediation, because as I just mentioned, we wouldn't need the convention for us to enforce the settlement. So it has been, I think, and that is one of the, I think, main reasons, or not the reasons, but maybe one of the important points of the Singapore Convention. It is to stimulate the use of mediation by these states in commercial businesses and transactions, to make it happen more than it is right now. So, I mean, that would be a point. And that would stimulate the use of mediation by these practitioners. I see we have questions in the chat, but I don't know if we're going to answer them now or leave it to the end. But I think the change in culture, as Monica mentioned, it's really slow. We have a clash of generations, I think, because we have a generation who's active in mediation procedures but hasn't had the training. And then we have the young generation having the training but not being able to practice in these cases yet. So I think I'm optimistic as Filipa is. I think we have a long way to go, but I think we're doing well. And she was saying when you asked her about, just a personal note, when you asked her about Portugal, when I lived there in 2007, from 2007 to 2010, I think, the university, the Nova University in Lisboa, they had back then, and I know they have it, they still have it now, but they had back then a project of a virtual lab to solve consumer and other small conflicts via mediation, online mediation and online arbitration. I was fortunate to be part of that project as a volunteer for a while. It was conducted by Professora Mariana França Gouveia. I know she's there. And so, I mean, they were, I think, ahead of us in 2007. The lab has evolved tremendously. I know they have lots of cases now, and it changed a bit. They actually, back then, they had this interface with Second Life, which was like a virtual media thing back then. But so I think we have this, we have to see, that was my comment, we have to see the Singapore Convention as this big incentive by the states for the use of commercial mediation, which has been growing, I mean, in Brazil and in Portugal, as we have seen.
Well, thank you, Isabel. Actually, I think it's a great transition to our final points, because you touch upon this paradox of so-called voluntary dispute resolution mechanisms such as arbitration and mediation, because they supposedly rely on freedom of contract, but in the end, when the parties are not willing to abide by what they agreed, then there needs to be enforcement. And then it's not so freedom of contract anymore, kind of, right? So the question here is actually the Singapore Convention a game changer for mediation itself, because now it's enforceable? What do you think, Filipa?
So if I can just go back a little bit to the arbitration part, and now I really mean to say arbitration. Don't get me wrong, because I'm a big fan of arbitration. Although I do relate to something that the panel before said, that arbitration is a bit like democracy in the words of Winston Churchill. Although it's not perfect, it's the best that there is for many problems. But I do think that I see arbitration and mediation as complementary. It's very frustrating sometimes when you're acting as an arbitrator to see a dispute that could perhaps be easily solved through mediation in a much more effective way, even if you're a very effective arbitrator. And I think it's good for us lawyers. I don't think it is a threat for arbitration or for arbitration lawyers. It's just another tool that you can use to satisfy the needs of your client. And whatever satisfies the needs of your client is not a threat to your practice. So this is the point about arbitration. About mediation, and I was glad to hear Isabel, because we did not discuss this before, and I see that we share a lot of ideas that not everyone shares. So starting in the beginning, the New York Convention, everyone knows, was crucial to make arbitration the preferred method of international dispute resolution. Professor Diego Fernández Arroyo gave a very good conference some years ago about this in Lisbon. And it's a cliche to say that it's the most successful international private law treaty. And the Singapore Convention is brought to you by the same people that brought us the New York Convention, the UNCITRAL Working Group 2. And also it draws a lot upon the New York Convention. If you have read the two, the similarities are, they jump in front of you. So you put this together with the fact that for many mediation believers, the mediation era has been a long time coming. There is this thing, there are a lot of paradoxes in mediation, and the mediation paradox describes this thing that how come you have something that allows you to reach settlements in, let's say, 80% of disputes. These are CEDAR figures, and some other institutions have 75 or something along that zone, but is only used in 1% of the disputes. And this is a figure of a study by the European Union. So people want to see this thing that they know it works used, and so they have concentrated all their hopes in the Singapore Convention. And you see a lot of articles saying it's a game changer for mediation, but I have some doubts that the Singapore Convention will be for mediation what the New York Convention has been for arbitration, because the context is different. It's not replicable. The times were different. State attitudes were different. And the alternatives that were available were different. And so I don't think we're going to see the same thing, but very happy. I hope I'm wrong. You never know. So let's wait and see. I do think that the Singapore Convention has some advantages. I share Isabel's doubt as to whether we really need it. I think there's an important difference with arbitration, because arbitration, in the end, there is a decision that is imposed upon the parties. They are not part of the decision, and someone else adjudicates the dispute for them. In mediation, in mediation, the parties take ownership of the dispute and they decide if they want to settle or not, and what is the settlement that they want. And so it's much easier, and figures, although it's sort of anecdotal evidence because of confidentiality, suggest that most settlements reached through mediation are voluntarily enforced. So I'm not sure that we needed this. But as someone else in the first panel was saying, lawyers are totally risk averse. So if this means that 10 people that would not include mediation in their contract are now going to include mediation in their contract because it is enforceable, I think that's great. And it is true, as Isabel was saying, this provides an opportunity to discuss and divulge mediation. It provides momentum for initiatives around mediation, for states to adopt a mediation law, to revise their mediation law. And perhaps most importantly, it legitimizes mediation as a form of dispute resolution. And I think that is very important, because some people still have this idea that mediation is sort of a hippie thing, or with a lot of psychological mumbo jumbo. And it really isn't. And or things like that Latin people, and I'm talking about my own preconceptions before I saw the light. So again, I'm not judging others. That Latin people are very hot-blooded, and so they are never going to be successful in mediation. But I think that's not true. I think Patrick was also saying that people, if not for time and money, the destruction and disruption that disputes bring to relationships, that is a point where mediation is very good. And so what I think that the Singapore Convention fits very well into a trend that I see of things that either facilitate mediation or a trend towards mediation, or trends that will facilitate mediation in the future. And I just want to say something that José Ricardo was talking about bad settlements. Mediation, I know you were not talking about mediation, but mediation is not about bad settlements. It's about getting the best, or not the best, but an acceptable settlement for both parties by, among other things, trying to think of ways of expanding the pie. So it's not about a bad settlement. I'm losing my train of thought. So just some of these trends. I think COVID is a good thing for mediation. We'll see, we'll see. But the fact that we are all experiencing something that has completely disrupted all of our lives and creates disputes where the other party does not necessarily have to see the opposite side as to blame, because this is something that has happened to us all, where things like, will you be solvent when we get to the end of arbitration or whatever the mechanism that we are going to solve the dispute? This is a very big incentive to use mediation to try to solve your dispute now. Even before COVID, you could see big law firms every year publish their predictions for the year, and you see top firms already before COVID saying that there was a trend to use more and more mediation. We're now seeing a lot of talks about investment mediation. So this was already the truth in the poll last year, and it continues. So mediation is expanding in terms of not beyond commercial mediation. I think clients are more educated, more savvy. They don't rely so much on external counsel that has resistance to change, to try things that they sometimes do not feel comfortable with. And they have less and less tolerance for a lot of time and a lot of money and energy lost in discussing something that you might perhaps resolve through mediation. You see the fruits of the ICC competition that includes, for instance, lawyers and future lawyers and future non-lawyers. So business people are being educated in mediation, and all these competitions, all the things like what Nova does that has introduced mediation in the curriculum. People are being educated from an earlier age in mediation. So I think all of these things, there's a focus on dispute avoidance that is much more mediation close, so to say, than arbitration close. And we see all these things, so I think that we will be seeing mediation more and more. Big firms are doing it. And even if you're from a small country like Portugal, lawyers and companies, if they want to stay competitive in a globalized world, need to get to the program and learn the techniques that other people are learning, or otherwise they cannot be competitive. So I think this is the best pitch for mediation that I can do. I think we will see changes, and the Singapore Convention will be part of it, but it's not the sole factor.
Definitely. No, and I think Isabel and you both highlight or give hints on the synergy. Also, Monica, give hints on the synergies between mediation and arbitration and other methods of dispute settlement. While you were talking, I was thinking that we see that actually many investment treaties, they already provide cooling off periods and negotiation phases. So it's the fruits, the low-hanging fruits are there. So there's space for mediators to come and pick them potentially. So our final closing question is, what are the challenges for the adoption of the Singapore Convention? Because this is a recent instrument. I was checking the status today. I didn't see Portugal among the ones that signed even the convention. Brazil has signed in 2021, but we still haven't ratified. So, Monica, what do you think are the challenges for the adoption or the entry into force in Brazil of the Singapore Convention?
First of all, I couldn't agree more with Filipa about what she mentioned about the education and changing the business people trying to be more curious about mediation. That is very important for the whole process. Because what I'm trying to say that in my point of view, the most important challenge for the adoption is not the legal procedure, the legal path. It's much more the culture. Changing culture is the key for the adoption of the Singapore Convention. As you mentioned, Brazil has already signed, and it's important also to highlight that a lot of institutions, organizations, including CAM-CCBC, work together to give support to the government people to just justify the signature by Brazil. So the legal issue is not a big problem to adoption of the Singapore Convention. In my perspective, we are exactly talking about changing culture, changing this scenario, and with mediation is a small talk, is nothing technical, anyone can do it, any lawyer can just sit in the table and fight for their clients. And so this movement can encourage and give more speed for the adoption of the Singapore in Brazil. I'm talking about Brazil. I don't know in the other countries. I'd like to listen.
Any thoughts, Filipa, on?
I know that currently I think it's 55 countries that Australia has just signed, but there are only 7 ratifications. In Portugal, the problem is that the European Union is deciding for the entire European Union. So, and there seems to be an impasse. I don't know if the European Union recent experiences with arbitration have made them more weary of signing conventions like this, but I know this is a difficulty. It is true that within the European Union, you already can enforce most mediation agreements. So this is just a problem, and you don't have necessarily a reciprocity clause. So in perhaps what is a very selfish thing, you can enforce agreements within the European Union, and you can perhaps enforce them in countries that have signed and ratified the Singapore Convention, even if you have not done so yourself. So this is the most that I can add on this point.
Well, I think we still have maybe a few minutes just to address what the question that was written in the chat. So this one is for Filipa and Isabel and comes from Patricia Fuoco. And she asks, can you give us, in the case, Filipa and Isabel, can you give us a hint to try to persuade lawyers to learn about mediation advocacy? How to persuade lawyers that it is important to...
So you want me to advocate on mediation advocacy?
Yeah, apparently.
But I don't know if you want to go first, Isabel.
No, it just calls my attention that I think we have a different movement in mediation than we did in arbitration, because I think when in the beginning of arbitration, we tended to have lawyers convincing clients that it was good to use arbitration. And now I think we can see the other way around. We just heard in the first panel, for example, Rodrigo from Tequinte saying that if we settle the dispute, we are winning. I just noted when he said it. And I think I think mediation got to the corporate world before it got to the lawyers. The lawyers use, not the mediation lawyers like trained for that, but the great majority of litigation lawyers, they still have, I think, a resistance to mediation practice. And I think answering Patricia's question, I think the necessity of the clients and the pressure from clients, I think, is one way to persuade lawyers to learn more about mediation advocacy. Because I have seen in more than one situation that the behavior of the lawyer was one of the factors, not the only one, but one of the factors that made the mediation not work in that case. The parties were very eager to settle, but sometimes the practice, the way that the lawyer practices the mediation, defends or tries to defend the client instead of bringing the solution together is one thing that makes it impossible for the parties to settle. So I think this is one of the hints. I don't know, Filipe, if you have other insights.
I think that mediation advocacy always entails learning about mediation. And these are skills that you can use in mediation and outside mediation. It makes you a better negotiator, and that's a skill that every lawyer will have use for at any point in their lives. I think mediation will come, and when it comes, you want to be prepared because it lessens your discomfort with trying something new. So it puts you more at ease. It's easier to impress your client. It's easier to get a better result of mediation if you can understand what's going on and know how to make your arguments heard. So I think it's a no-brainer, really, but to complement what Isabel has said.
Well, thank you very much. Then I think our time is up, but you still have okay. So we have a question from the live audience. So you can present yourself.
I had a question maybe for Filipe. So as we know, confidentiality is a fundamental feature of mediation. But do you think that in order for mediation to grow bigger and as popular and effective as maybe arbitration, we would have to derogate from the feature of confidentiality just a little bit?
So I'm not sure if everyone heard the question. So I'm going to repeat it. Sasha asked the question on confidentiality. So she says, no, confidentiality is a big feature of mediation, but would it be necessary to move away from confidentiality so as to promote mediation as a more widely accepted mechanism of dispute settlement or dispute avoidance?
First of all, I think confidentiality is essential to arbitration. I think that's one of the reasons why it works. And even the caucuses, which is a tool that the mediator can use that you don't have in a negotiation, just two sides, build on that idea. So I think that we should be careful of not damaging things by trying to promote them. And this being said, although by definition or by law, arbitration was not confidential around the world in many countries, in some of them was, that did not prevent arbitration from being widely used. I think what we need to do is people that are interested in mediation speak in an echo chamber and they are just talking to themselves. And what we need is to have discussions. So I again congratulate the organizers today. We need to have discussions about mediation in forums where potential users and lawyers are, so that they understand the benefits and that they can learn more about it. And confidentiality does not prevent you from sharing success stories. So we need better marketing and not less confidentiality. Thank you for your question. It was very interesting.
Any thoughts, Isabel and Monica, on the question?
No, I agree. Yeah, I agree with Filipe.
Totally agree with Filipe. I think confidentiality is something very important and we have to preserve that. And exactly this, we can share the successful stories and we know a lot of them and you have to tell them that is important and bring this new, that mediation is something good for the clients and also for the lawyers. A modern lawyer have to know how to act in the table or mediation table and what kind of skills I need to work in a better way, to be a better lawyer, a very good lawyer for my clients. So I think in the future, a lawyer who doesn't know this kind of mediation skills would be not a good lawyer. He will lose market. It's not a good,
And now we also have online mediation, so there's other skills for us to learn.
Yes, much more to learn, a lot of things to learn, because it's not the same. Mediation, presential mediation in ODRs are other things, other skills to learn, and I don't know if we have enough time. because I think Gary put an answer.
Exactly. There is another question in the Q&A.
Another question.
So Gary is asking, a central question that needs to be addressed is how mediation will be incorporated into the practice of arbitral counsel to further clients' interests. How arbitration lawyers will incorporate mediation, or will they? That's the question. But I think this has been somewhat addressed throughout the panel, in the sense that we need to have a change in culture for lawyers in general, but also for arbitration lawyers, in the sense that maybe we need to foster non-conflictive, less adversarial methods.
Open and curious. I think people must be a little bit curious about the method and try to understand what we are proposing, the mediation. So, and be open to that.
Yes. Well, but unfortunately, we have run out of time. This is the end then of our panel. Thank you very much, Isabel. Thank you very much, Monica. Thank you very much, Felipe. This was very insightful.
Thank you.
We have now scheduled in our program a very short break. So let's take 10 minutes and come back at 5:20 here in Paris. And I believe it will be, I don't know, in 20 minutes in Brazil, because I can't calculate that.
Enjoy the break for us.
It's like 10 minutes break. So everyone, the audience, let's come back in 10 minutes.
I'm ready.
Should we try to start or should we?
Try to start. Let's try to start.
All right. Okay, just give 2 seconds for everyone to settle. Good afternoon, everyone. Welcome to this third panel after the coffee break. We will be discussing now the clash between common law and civil law in international arbitration, myths and realities. And to discuss this topic today, we have a great panel of civil lawyers. So you can already understand that we will highlight the advantages of civil law over common law, but we will welcome any comment from the audience if we have common lawyers among the participants. Before I introduce, and let me start by introducing our speakers today. And we have an in-person female panel, the second one of the day, and then on the screen we have one man to complement it. But on my left side we have Flávia Mange, founding partner of Mange & Gabet in São Paulo, Brazil. On my right side I have Marie-Isabelle Delleur, a senior associate in Clifford Chance in Paris. She's also Brazilian. And on the screen I see Adriana Braghetta, founding partner of Adriana Braghetta Advogados, also in Brazil, and Giovanni Nanni, who we see on the little screen up there, founding partner as well of Nanni Advogados in Brazil. And you know, when I was writing an article with Patricia Ferraz in Brazil on the history of the ICC rules, that arbitral institution that was created in 1923. And the article that I was reading, you know, the history of the rules, and I found extremely interesting, and I immediately connected with this panel today on the discussions in the 1927 rules of arbitration. And there was a discussion on whether arbitrators needed to provide grounds for awards. This was the discussion. It was a very small group of businessmen discussing the ICC rules. And we can read in the discussion, there are you know, draft minutes of those discussions, where we can see that there is irreducible opposition between the British points and that of several continental countries. In England, the general rule is that the arbitrator shall not state the grounds of his, of course not her, awards. As these grounds, again, this was written in 1927, as these grounds might later be relied upon by the loser seeking to set aside the award by the courts. On the contrary, in Europe, it's customary for arbitrators to state the grounds of their awards. And there are even countries, those crazy countries, such as the Netherlands, in which an award does not state the grounds on which it is rendered. If it does not state the grounds, it will be null and void. The committee was a bit puzzled by this, you know, clash between both civil law and common law approaches, and considered that it would be impossible to leave the decision to the arbitrator, who was to be a businessman without much knowledge of international law and international arbitration, actually. So what was the outcome of those discussions and the proposal that was actually in the 1927 rules of arbitration is that the court will have discretion to decide whether the award would have to set the grounds or not. So I thought this was an extremely interesting debate. One also that shows us that the debate we're going to have here today is not, it's not the most innovative debate. It has already at least 100 years. But we will not discuss specifically the awards, which I think it's an interesting discussion as well. We had a very long list of topics that we could discuss here today, but ultimately in the interest of time, we had to reduce it. And with that in mind, maybe we can start by the origin of these different legal traditions. And I give the floor to Giovanni in that regard. Giovanni.
Good afternoon, everybody. I hope everybody is safe and fine. It's a great pleasure for me to participate in this event. Although here in São Paulo, not in Paris, I hope I'll be able to be there in person next year. I would like to thank Diego Arroyo and Eleonora Coelho, as well as Bruno Rodrigues, Renato Grion, and José Ricardo Feris for the kind invitation. It's a pleasure to share the panel with Anna, Adriana, Flávia, and Marie-Isabelle. The topic I'm going to address is about the codified perspective, common law and civil law, different origin of lawyers and arbitrators. First, I'd like to start with the premises. International arbitration is founded on the premises that the disputes arose among parties that generally are based in distant countries, use various languages, adopt different legal systems, appoint arbitrators of diverse nationalities, backgrounds, and jurisdictions, and consequently are subject to different legal cultures. On a comparative law perspective, the traditional legal families theory seeks to provide the answer to several distinct questions on the matter. Although the issue is still being discussed, for me it's clear that the framework, the source of law, and other important values continue to be associated to nationals or domestic mindsets. On the other hand, it's well known the tendency of uniformization, such as in private law, UNDROIT principles, CISG, principles of European contract law, draft of European contract code, and draft of common frame of reference. So regarding a codified perspective, is there a clash of common law and civil law in international arbitration, considering the different origin of lawyers and arbitrators? I would like to mention two important factors for the discussion of the subject. First is the mode of legal thinking, and the second is the frame of mind. With respect to the mode of legal thinking, Zweigert and Kutz, two major authorities in comparative law, mention that another hallmark of a legal system or family is a distinctive mode of legal thinking. Thus, the Germanic and Romanistic families are marked by a tendency to use abstract legal norms, to have a well-articulated system contain well-defined areas of law. On the other hand, when one looks at the very different situation in the common law, one realizes just how distinctive the stylistic elements are. Regarding the frame of mind, the role of the advocate, the methods of legal education, the forms of the procedure all differ widely. In arbitration, the common law and civil law tradition also contrast in how legal arguments are developed and presented, how evidence are produced, and how hearings are conducted. Roscoe Pound describes the difference behind the characteristic doctrines and ideas and techniques of the common law lawyer, that there is a significant frame of mind. It is the frame of mind which actually looks at the things in the concrete, not in the abstract. So it is a frame of mind of dealing with things as they arise instead of anticipate them by abstract universal formulas. It is important to emphasize that these quotations are not exactly recent. One may criticize these topics, saying it is a simple and non-representative description of the circumstances. Indeed, the difference between common law and civil law are not so simple. In addition, the essence of the two families is no longer placed in opposite sides, as it was in the past. The differences are being reduced in the last decades in several approaches, in special among practitioners of global or multinational law firms. If we focus in the selection of the arbitrator in a dispute governed by the substantive law of a civil law country, who would be the most suitable arbitrator? A common law or a civil law lawyer? Or it would depend on the case. What I would like to propose here in this brief intervention is a discussion of pros and cons of appointing a common law lawyer. Pros: transnational and global ideals and trends. Establish for arbitration an international space autonomous from national legal system and traditions. Neutrality. A party will often prefer to submit their multi-jurisdictional dispute to a neutral tribunal or at least presiding arbitrator. And third, efficient procedure. Arbitrators and lawyers from different backgrounds can contribute to the efficiency of the proceedings by incorporating useful mechanisms from their own jurisdiction to the conduction of the arbitration. And cons. First, lack of familiarity. An arbitrator that has not been educated with the concept, for example, of a civil code is not truly prepared to decide upon complex legal issues. Second, decision-making process. Arbitrators may want to apply principles deriving from their own legal background in the solution of the dispute, or even interpret the applicable law in light of their own legal tradition, which may affect the award. And third, uncertainty of the decision. An arbitrator may decide different to a local court or a panel form of free civil lawyers. So in order to conclude for the debates, I would like to ask 3 questions. First, is it really relevant if the arbitrator is a common law lawyer or a civil law lawyer, if he or she is truly experienced in international disputes? If it's not relevant, how to identify he or she? Second, how about iure non curia or iure non arbiter? And third, is it a myth or a reality to affirm that is a mistake to appoint an arbitrator that is definitely not familiar with the civil law system? With that, I conclude my initial presentation. Thank you for the opportunity.
Thank you, Giovanni. And you concluded with three interesting questions that we hope with the other presentations we will be able to reply at the end of this panel. But definitely on the second one, we have a very long and interesting debate yesterday on the approaches, civil law, common law to iure and non curia, because we had Julie Bedard with us who actually covered that part. And I guess it will be, it was recorded and it will be available for everyone benefits. And I was thinking while I was, listening to you, because this is sometimes a discussion that we have when we need to appoint the president, indeed, when you have parties or the law applicable, and sometimes you have more than one law, and it may well be that it's one from a civil law tradition and common law tradition. But even when that's not the case, because that's less common, you have many times, and that's the case in Brazil, and I guess some of you will share the experience of when the law applicable to the marriage is Brazilian law, but the place of arbitration is, for instance, New York. And we tend to think that between, it's more common for Brazilian parties to choose New York over London. I may be wrong, but that's my impression, or even Miami. And it's still important, right? Even when the law applicable, it's Brazilian law to the marriage, the impact that lex arbitrii may have on the selection of the president of the arbitral tribunal. But with that, I give the floor to Adriana, and Adriana will discuss also an interesting point regarding these two different traditions, and that's document production. An easy topic to cover in 8 minutes, Adriana. You have the floor.
Thank you, Anna. It's a pleasure. Can you hear me well?
Very well, yes.
Okay. I'm here at the premises of the CAM-CCBC Hearing Center. So it's interesting also that everything's is already prepared also for the hearings. I would say hearings in person, also in person and with virtual participants. So it's a pleasure to participate, to be invited again. Thank you, Diego. Thank you, Eleonora. Really envy of Flávia, that is sitting there in Paris in a sunny and beautiful day. But Giovanni and I will have to be next year there to at least try to catch up a little bit. So guys, in relation to the theme, I'm very fond of this theme, because picking up on what Anna has mentioned and Giovanni has mentioned, it's antique, it's an old theme, has evolved drastically in 100 years, but it's still there. I think when we are dealing with a case in which all the lawyers are well versed with international arbitration and also the arbitral tribunal, in relation to document production, I would say that differences, we may conclude that differences may be a myth at this stage, 100 years after what Anna was mentioning about the differences in writing the award and giving reasons to the award. But pay attention to what I'm saying. It's a very unique scenario. Arbitrators and lawyers extremely well versed in international arbitration. So everybody knows what to expect from the other party. And arbitration, international arbitration is not only for the ones who are versed. We need to include other people. In the last 20 years, we've been discussing all about diversity. We've been discussing all about bringing other regions to this club, to this mafia, Asia, Africa, South America. I also think that in due course, try to see what's going to happen in 20 years, because all young lawyers are practicing since the early stages at the Vismut competitions. Obviously, probably in 20 years' time, we will have more of a universal procedure that everybody will be familiar with. But when we are talking about document production, and I would like to share with you a PowerPoint. I think the major and difficult aspects of it, if the host can enable a PowerPoint, it's okay. If not, it's okay. I can deal with without it.
We'll do it. You should be able. Let's see.
And please, you can go down a little bit.
Yes.
Jonathan, the second one, please.
Yeah.
What's it say? Yes. So obviously, when we are talking about, I'm not going to talk about Prague rules. It's a disclosure that I made because I think they don't have the legitimacy to be largely used in international arbitration. And to my understanding, they are also two-sided with the civil law approach. In any event, I think that when we take into consideration what we have within the RBA rules from 1999, revised in 2010, and revised now last year, in 2020, it's totally well accepted when we speak broadly. So they are very good breach. We all know that about civil law and common law traditions. Still, but there's still some cases in which civil law lawyers, especially from Brazil, they do not accept the use of IBA rules. But obviously, they are good bridge. We all know that it's totally different from a fishing expedition. Civil law lawyers feel comfortable because it will be only specific documents or a specific set of documents. Generally speaking, when we use the red phone schedule, it's very rare that an arbitral tribunal will allow the production or will request the production of the document if it has nothing, it's not proved to be related to the essence of the case. So we are okay with that. The main issue, and Jonathan, please, if you can, the main issue, it's what lies underneath the production of documents. And this issue has to do with more broad aspects, and has to do with what also Giovanni mentioned. It has to do with ethical rules. It has to do with privilege rules that to some extent are unknown to us civil law lawyers, especially in Brazil, and has to do with expectations. Even if we look at the IBA rules, when we pay attention to items 9.2, 9.3, 9.4, has to do with the avoidance of reduction of documents. It's interesting to notice those expressions that are very broad. Let us see, for instance, item B, the arbitral tribunal shall, at the request of the party, motion exclude the production in case of legal impediment of privilege under the legal or ethical rules determined by the arbitral tribunal to be applicable. Which are those? They still vary a lot. Again, Article 9.4, in considering issues of legal impediments, and insofar as permitted by the mandatory legal or ethical rules that are determined by it to be applicable, the arbitral tribunal may take into account the expectations of the parties and their advisors at the time of the legal impediment or privilege is said to have arisen. So it's a very tricky scenario in which we need to think. And then I want to also bring into our discussion what is written in the IBA party representation rules in relation to counsel ethics, obviously trying to reach another level of harmonization in terms of document production. Item 12 says, when the arbitral proceedings involve or likely to involve document production, a party representative should inform the client of the need to preserve those documents so far as reasonably possible. So, in fact, when I see when we pay attention to the IBA rules on taking of evidence, and in connection with the IBA rules on party representation, what we can conclude that there is still it is still a reality, this clash. For instance, in terms of ethical rules, it's impossible to say that to a common law, to a civil law lawyer, especially a Brazilian one, we have the duty to tell our clients to collect, retain a document for him or her to produce in an arbitral proceeding. So for me, Anna, this is the main aspect of the case that's truly difficult to deal with. We cannot prejudge if the ethical rules of a Brazilian counsel are improper or not. We cannot judge if the ethical rules of American lawyers is improper or not. This is the difficulty is that we need to deal in this reality in which we have expectations, we still have expectations and ethical rules that vary drastically. So what to do in a situation that we have to deal with all this diversity? This is the beauty of international arbitration. I love that. I love those difficulties that we need to overcome. I think the golden rule here, it is transparency. Transparency in relation to parties' expectations into the proceedings, you know. I think whenever we are facing a conference hearing to organize the proceedings, or whenever we're dealing with document production, not only arbitrators, but the parties' counsel need to address and should be able to address this issue in a very frank and transparent way. Even to say, you know, according to my ethical rules, I cannot tell my client to produce, or I cannot tell my client to retain documents. And we can assess how to deal with those differences in a specific case. Ana, these are my preliminary comments. Thank you very much.
Obrigada, Adriana. Indeed, it's a very interesting topic. I was wondering while you said that you do believe that the IBA guidelines on taking of evidence build the bridge between both legal traditions. I'm not sure Carmona would agree with you on that point, but we are lucky enough of not having.
He's wrong.
No, but I was wondering because then you said that it's not used frequently in Brazil. And I was thinking exactly about that because we see it widely used these days.
One point, Anna. Sorry to interrupt. If you understood that, let me rephrase it. It's widely used in Brazil, but in a few cases, even international cases, council prefer not to put it in expressly. But it's widely used here. Sorry to interrupt.
No, because I was thinking that actually I don't see many times the arbitration agreements I have the feeling in Brazilian cases making reference to the IBA guidelines on taking of evidence, and to a certain extent, the same for the terms of reference. So I was wondering whether, there was still a feeling that the IBA guidelines in that regard gave or prevailed the view of the civil law, the common law tradition instead of the civil law. But it's just an interesting point of debate. And I would say that on top of transparency that you mentioned as a key principle, I think that flexibility as well, because it really allows and grants the power to the arbitral tribunal to manage those different expectations in a way. I was going to ask if anyone has any comments on what Adriana just said.
I think an important point that I think we should bear in mind is, although now the IBA rules are very much accepted in international practice, still document production is a very common law tool. It's not something that our litigation friends in civil law jurisdictions are used to. The fact that you can ask a party to produce documents in proceedings, that's very common law-like. And so the reaction of external counsel to the phase of document production, even in international arbitration, we've experienced counsel will vary from a counsel that is from a civil law jurisdiction. As Adriana said, you have to tell your client that he has to preserve documents, but you may not tell your client you have to produce absolutely everything that you find, even if it's detrimental to your case. But a common law lawyer, he will do that because he has an ethical obligation to do that. And another point that I think Adriana mentioned that is very important is that of expectations of the parties. Because document production is a tool from common law jurisdictions, it's also a tool to which in-house counsel are used. So in-house counsel, in the way they communicate with business people in the companies they are in, they know that maybe that their communication are protected, and so they state things or not because they know what can be produced and what cannot be produced. And in-house counsel communication in civil law countries are not privileged, and so they are subject to document production, and there may be a lot of things in there because in-house counsel do not expect that their communication will be produced. And so that's a very important thing to bear in mind. And there the IBA rules have a very good point. I remember a case where we had an arbitrator that has sort of a dual background. He's American French, without giving you too many hints as to his identity. But we had a case where we had parties that were from several jurisdictions, and one party was asking for a lot of documents that were in-house counsel communication, and he had to decide whether these were privileged or not because the parties were arguing privilege and included those documents in the privilege log. And he gave a very well-reasoned procedural order on document production, exactly basing his decision on the expectations of the parties and saying, the rules of privilege for in-house counsel vary from jurisdiction to jurisdiction, and I need to take into account what the in-house counsel at stake expected, whether they expected that these documents were subject to production or not. And that, I think, is where the clash is more significant. Although we arbitration lawyers, we use those sort of common rules. We've included, even when we're civil law lawyers, we've included document production in our practice, but the people we're dealing with at the client, they don't have the same expectations and the same habit of what it means.
Very good points. And we will stay with you, Marie-Isabelle, and on another quite interesting topic, and one that actually at the scrutiny level we raise with arbitrators often, and that's the burden and standard of proof. What are your thoughts?
Yeah, thank you, Anna. First of all, I'd like to thank the organizers for inviting me. It's a pleasure to be here in person, and it's always a pleasure for me to come back to Sciences Po, which was my home for many years. So I'm really, really glad to be here. Actually, and I think the point you made in the introduction was very interesting, your comment on the reasoning of the awards, because it shows that the clash between common law and civil law actually translates in very different terms in arbitration, because I don't know if you've read an English court decision, it's usually very reasoned. I don't know if you've read the Cour de Cassation decision, usually not so much. So it's funny that in 1927, they were discussing that English arbitrators do not reason their awards, but French arbitrators do reason their awards. So the clash exists. But is it really because it comes from the rules that that are applied in the jurisdiction, or are there other cultural things that come into play that are not really related to the legal background? And so burden and standard of proof are interesting also in this regard for the clash. They are very important concepts in adjudication in general, either by judicial courts or by international tribunals. Just to remember the difference between the two, burden of proof relates to who bears who has to prove, who bears the burden to prove, and the standard of proof is related to how much has to be proven by the party who has the burden of proof. And applicable law is significant because there is differences in the way common law and civil law approach these concepts. Maybe we'll leave for later discussion, if we have time, how you determine the law applicable to these questions and whether there are questions of procedure or of substance, because that's determinative to the applicable law. And I will focus more on standard of proof, because it's my impression that there is more of a consensus between common law and civil law on the burden of proof. Generally, both systems follow sort of a principle of actore incumbit probatio, which is that the burden of proof lies with the person making the particular assertion. There are some differences on when the burden may or not shift, but still that's a general principle that is kind of accepted in most jurisdictions. But by contrast, there are much more significant differences in the assessment of the standard of proof. So first, in common law countries, there are typically three standards for the standard of proof, depending on the degree of evidence that is required. The first one is balance of probabilities, then there is clear and convincing evidence, and beyond reasonable doubt. Generally speaking, in common law jurisdictions, the standard that is applied is the one of preponderance of evidence or balance of probability for non-criminal cases. Then in criminal cases, the standard is a bit higher. It's usually beyond a reasonable doubt, which is justified by the principle of presumption of innocence and the fact that society in general prefers erring on the side of acquitting guilty people than imprisoning innocent ones. So there is a higher standard there. But in civil cases, generally in common law jurisdictions, preponderance of evidence or balance of probabilities, which means that something has to be proved more likely than not. It's more likely to be true than not. By contrast, in many civil law countries, standards of proof are not really debated. They're not really dealt with in statutes, laws, and so you're pretty much at loss. But the truth is, in fact, that there is kind of one single standard that is applied both in civil and criminal cases. I'm speaking mostly about French law. There may be, of course, differences, but that's the jurisdiction in which I'm qualified. So I'll focus more on French law. And so the standard that is applied, I think in many civil countries also with an influence sometimes of French law, is the one of inner conviction, intime conviction du juge in French. And it's sort of a principle of free evaluation of the evidence. And when you see the discussions between scholars as to what this standard of inner conviction means, it seems to be a bit higher than preponderance of evidence in common law jurisdictions. What civil law asks is whether the facts are so probable as to create an inner, deep-seated conviction of its truth with the fact finder. And the inner conviction standard probably requires more certainty than the preponderance of evidence standard. And the same standard of inner conviction applies to criminal matters as well in most civil law jurisdictions. So the question is, does this distinction matter in international arbitration? And as you'll see, my answer is mostly no, but it's open to discussion. First of all, I think under both kind of systems, the ultimate goal of the parties is always to convince the judge, the arbitrator, the fact finder. And the standards in practice are not that different, because if you take preponderance of evidence, even if it's a bit low, it's also about convincing the judge of the likelihood. It's more likely than not, and the judge needs to be convinced deep down that it's more likely than not. Is it very different from what you require with the intime conviction du juge? Maybe the juge just needs to be really convinced that it's more likely than not. Maybe that's more or less the same standards. I think the standards are not that different in practice. What is interesting is to look at Article 22.1 of the UNIDROIT principles on transnational civil procedure that provide that facts are considered proven when the court is reasonably convinced of their truth. And this rule is clearly, because it's UNIDROIT principles, it's sort of an attempt to bring together both views. And I think the standard that is set forth by the UNIDROIT principle is actually pretty close to the one applied in common law jurisdictions and pretty close to the one applied in civil law jurisdictions. It's acceptable for everyone, I would say. And when you look at what's being done in international arbitration in practice, usually arbitrators apply a standard that is close to the balance of probabilities. You have a lot of cases, notably exit cases, where you see that this is really the preferred standard for arbitrators. Now, you have a second question, which is sometimes arbitrators feel like they need to depart from this standard to apply a higher or lower standard. For instance, you have decisions on corruption allegations where a higher standard is applied. You have some decisions on damages, for instance, where a lower standard is applied to the proof of damages. And so there is a question whether there should be a different standard than the regular balance of probabilities, widely accepted one in international arbitration, depending on the issue at stake. I would say that where the governing law requires a higher standard, which may be the case, because the governing laws, even though you have this sort of standard that is the generally applied one, you have some subtleties in all applicable laws as to, for some facts, maybe the standard will vary a little bit. And if the governing law mandates that a higher standard of proof is applied, for instance, to the proof of corruption allegation, then of course it's justified for arbitral tribunals to elevate the standard, to apply clear and convincing evidence or beyond reasonable doubt standards. But the question is where the governing law does not mandate that. Is it justified for the arbitrators to depart from the applicable law and to hold the parties to a different standard, depending on the allegations at stake? And that I'm not sure is justified, especially if we consider that standard of proof is a matter of substance rather than procedure, because then the parties will really expect that the standard set forth in the applicable law will prevail. So maybe it's not justified for the arbitrators to depart from that standard. And I think to conclude, what we notice a lot in actually decisions from arbitral tribunals in an international context is that very often commercial good sense prevails over the applicable law, even if they're not supposed to be ruling in equity. Sometimes you see that they introduce some kind of blended elements that are tainted with this commercial concern in their application of the law. And when they have an international background, maybe they're duly qualified, maybe they are qualified in one jurisdiction, but practicing in another, actually the standard that they apply is quite standard and very much in between what you see in common law and civil law. So I'm not sure the clash is that strong. In fact, exactly. I think it's more of a miss, but I'm happy to discuss. There are different views.
Thank you. Marie-Isabelle, super interesting. I think Flávia has a comment.
Well, just a short comment. I will not get into the choice of law questions because I think that's like a big deal to discuss. Exactly. But then considering like we already find which is the law we will apply for standard burden of proof. Is it a business, is it a judgment rule, or is it something that the parties will have to argue? And then I will just make a connection with the question Giovanni places. Would that be a iura non vita arbiter if the arbitrator decided to place a higher or lower standard of proof without allowing the parties to argue on this point.
Well, and you mentioned scrutiny, Anna. I think
Exactly.
Yeah, I think standard of proof is so outcome determinative. You cannot decide on a standard of proof that you've not submitted to the parties when you're an international arbitrator. I think it's very tricky to elevate or lower the standard of proof.
How many times have you seen that being discussed?
That was exactly what I was going to say, and that's my feeling, and that's why at the scrutiny level we raised the issue so many times, that many times we have the feeling that it was never properly discussed, and then there are these very broad statements stated in the award, and you wonder what is the legal basis. So please refer to the legal basis, to this principle that the arbitrators are saying are applicable. That's the tip of the iceberg. And you mentioned, and we will not discuss that today for sure, but you may have an interesting discussion with José and Ricardo on the corruption cases and the standard of proof on those cases. And there you see more of a discussion normally now on the standards. And with this in mind, and also because we are running short of time, I give the floor again to Flávia to cover the last interesting topic of witness statements and cross-examination. Flávia.
Thank you, Anna. Well, as Filipa mentioned, I was thrilled when I received the invitation for this chat like 2 years ago, and I bought my flight tickets like the day after. And I'm really happy and thankful for the organizers that you didn't decide to have a virtual conference last year so that I could use my ticket and especially be here with friends. And I'm really happy that I'm sharing this panel with Anna, Marie-Isabelle, Adriana, and Giovanni. So, well, considering we are in the Brazilian forum and that I am myself a Brazilian practitioner, I intend to briefly discuss the clash of common and civil law systems from the Brazilian perspective. In other words, I will take as the threshold, on one hand, what Brazilian civil law is, and on the other hand, what the practice in Brazil associates with common law. And this is so because, as already mentioned several times, there is no single civil law or single common law approach. But this varies a lot. So I will address this difference when it comes to the use of witness statements, which is a very common practice in international arbitration, but not so common in Brazil. I had the great opportunity to start my career in arbitration here in Paris, like almost 15 years ago, working at Sherman Sterling in a case involving Brazilian parties represented by local Brazilian counsel. Witness statements were adopted in that case, and several discussions were raised during the course of that proceeding about the use of these witness statements. Almost 15 years later, I would say witness statements continues to be a controversial topic in Brazil. And I'm there to say that that might not be only in Brazil. However, nowadays, I think arbitral tribunals anticipate many of these discussions and about not only the adoption, but how witness statements are used, setting forth clear procedure rules at the outset of the procedure. Just as an example of how to address these different views, the ICA sourcebook on the drafting of procedure orders suggests alternative wordings regarding the use of witness statements so that the parties can choose depending on how they want to use witness statements. So I will highlight some of this difference about the use of witness statements. The first point I would like to address is the moment of submitting witness statements. From a common law perspective, it seems that it is most usual to submit witness statements at the outset of the arbitration, alongside